This, this House now resumes its sitting. Good morning, everyone. We do apologize for the very late start as we had to deal with some administrative matters first. At this time, I call upon the clerk. Please stand.
Affirmation for due execution of office. I, Joanne Williams Roberts, do solemnly and sincerely affirm and declare that I will well and truly serve His Majesty King Charles III and the people of the Virgin Islands in the office of Attorney General. Affirmation of allegiance. I, Joanne Williams Roberts, do solemnly and sincerely affirm and declare that I will be faithful and bear true allegiance to His Majesty King Charles III, his heirs and successors, according to law.
Please be seated. I call upon the Premier.
Thank you, Madam Speaker. Madam Speaker, I move a motion to amend the order paper. Under public business, which is number 7, Madam Speaker, I move a motion to remove Roman numeral 6, which is Liquor Licenses Act 2019. We'll simply move that to the next sitting, Madam Speaker. And I'm proposing that we replace that with a first reading for the Insolvency Amendment Act 2022. So the Insolvency Amendment Act would be the new Roman numeral 6, and all other items would remain the same. I so move, Madam Speaker.
Thank you.
Madam Speaker, I rise to second the motion.
Thank you. Honorable members, a motion has been moved and seconded for the removal of 7 public business Roman numeral 6, which is currently Liquor License Act 2019, and that will be replaced with a new Roman numeral 6, which will be a first reading of the bill entitled Insolvency Amendment Act 2022. Those in favor? Those against? The ayes have it. The motion has been passed. I call upon the Premier.
Thank you, Madam Speaker. Madam Speaker, I move that the bill shortly entitled Jury Act 2022 be read a second time.
I'm sorry, I believe insolvency.
Oh, I'm sorry. My apologies. Madam Speaker, I move that leave be granted to introduce the following bill standing in my name, shortly entitled Insolvency Amendment Act 2022.
Madam Speaker, I rise to second the motion.
Thank you. It has been moved and seconded that leave to introduce the bill shortly entitled Insolvency Amendment Act 2022 be granted. Those in favor? Those against? The ayes have it. I now call upon the Premier.
Madam Speaker, I introduce the bill standing in my name, shortly entitled Insolvency Amendment Act 2022. I will explain its provision at the second reading. Madam Speaker, I move that the bill shortly entitled Insolvency Amendment Act 2022 be now read a first time.
Madam Speaker, I rise to second the motion.
Thank you. It has been moved and seconded that the bill shortly entitled Insolvency Amendment Act 2022 be now read a first time. Those in favor? Those against? The ayes have it. I call upon the clerk to read the bill for the first time.
This act may be cited as the Insolvency Amendment Act 2022.
Thank you. I call upon the Premier.
Madam Speaker, I move that the bill shortly entitled Jury Act 2022 be read a second time. And Madam Speaker, I'll just say a few short words about the Jury Act. Madam Speaker, as we all know, the Jury Act came up in the Commission of Inquiry. There was a recommendation to expand the pool of jurors, that consideration should be given to expanding the pool of jurors. Madam Speaker, I understand from our judicial colleagues that currently there is a challenge as it pertains to the size of the pool, and there's some difficulty whenever it comes time to select jurors. Persons have some type of connection to the parties involved in the matter, and that has caused a challenge. Madam Speaker, of course, we legislators have a responsibility to ensure that persons are consulted as it pertains to any bill that we seek to pass here in the House of Assembly. We actually put off this second reading to allow the Deputy Governor's office, under which this area falls, delegated by the Governor, who has responsibility for the administration of the courts. We allow them the opportunity to be able to consult with the public. There was a consultation that I participated in as the person who is responsible for bringing this bill to the House. Of course, persons raised concerns about the bill, and these are the issues that we will have to deal with in debate and in committee stage. It's important to know, Madam Speaker, that the current act is very old and in need of modernization. According to the current act, every person between the ages of 18 and 60 who has any land or tenements in the Virgin Islands of the value of $4,800 or more, or B, has any lands within the Virgin Islands of not less than 100 acres in extent, or C, holds any office in the Virgin Islands at a salary amounting to the sum of $960 per annum or more, or is in receipt of any income from whatever source deprived of $720 per annum or upwards, shall be liable to serve as a special juror. Persons should know as well, under the current Act, persons who are residents, just based on that old Act that goes back to perhaps maybe around 1914 or so, persons who are residents can be jurors. This current Act, Madam Speaker, proposes that a person between the ages of 18 and 17 who is a belonger, holds a certificate of residence, is listed on the register of voters, or D, has been ordinarily resident in the territory for at least 10 years, is qualified and eligible to serve as a juror for the trial and determination of any criminal or civil proceeding before a court. This is a proposal, Madam Speaker, and as I have said before, our role when we come here to the House is to reflect the views of the people, and it's also to do what we believe is right first and foremost, and what's in the best interest of the people of the Virgin Islands. And while the issues are sometimes difficult, while the issues we don't have agreement on them, that is our task. That's what we have been elected to do, and that is what I intend to do as leader of government business, and I'm sure all members of the House intend to do the same. So having said that, Madam Speaker, I bring this bill before the House for debate and for further consideration in committee stage. And I believe, Madam Speaker, with the persons that we have in the room, we should be able to modernize this act, this current act that we have, and we should be able to broaden the pool as necessary, and so that the judicial system can function more effectively. Thank you, Madam Speaker.
Madam Speaker, it looks like I shouldn't speak on this bill, but Madam Speaker, I rise to second the motion, and while I reserve my right to make my contribution at a later stage in this debate, Madam Speaker, I so second.
Thank you. Honorable members, the floor is now open for debate. Leader of the Opposition, Honorable Fraser.
Thank you, Madam Speaker. Madam Speaker, this piece of legislation appeared to me somewhat like a hurricane, because I heard about it before I saw it. I heard so much about it. And the horror that I heard about this, that I was waiting for, was that I heard about trials without a juror or jury. And that piqued my ears, Madam Speaker. It cocked my ears. Because I was wondering to myself, who in the right mind could ever contemplate such a travesty of justice, where a person will be deprived of one of the fundamentals, a cornerstone of justice, which is to be tried by his own peers, a jury of his peers, and turn that responsibility over to a single judge. I said, Madam Speaker, that is something that I would go down fighting against. But I'm glad that it's not in this bill. I heard the Premier mention it. He mentioned it as being part of the recommendations from the Hickenbottom report. It just goes to show, Madam Speaker, the depth to which they were willing to go. And we are fortunate that we are able to be here today, Madam Speaker, to debate this bill. And we are also fortunate that that particular provision is not a part of this bill. And the only reason, Madam Speaker, that we are able to do all that is because recommendation number 1 of the same report has not been fully implemented. Fully implemented, I said, because the governor has it sitting somewhere on his desk or in a briefcase in his office somewhere. And he has the option of implementing it at any time. But that is not the case. Implementation at this time is not the case, Madam Speaker, because we have the bill before us, and that provision is not in here. But equally troubling, Madam Speaker, for the purposes of what we're here to debate, are some of the provisions that this bill is asking for. Equally troubling. And I look at Part 3 of the bill when you speak of qualifications of jurors. It says the qualifications subject to Section 6 and 7, a person between the ages of 18 and 70, inclusive, who A, is a belonger, B, holds a certificate of residence under Section 18 of the Immigration and Passport Act, revised edition 2013, C, is listed on the Register of Voters prepared under Section 23 of the Elections Act, revised edition 2013, or D, has been ordinarily resident in the territory for at least 10 years, is qualified and eligible to serve as a juror for the trial and determination of any criminal or civil proceedings before a court. As was mentioned by the Premier, Madam Speaker, the old Act, or the current Act, I should say, does make provisions for a series of persons who would qualify, but D is not a part of it, which says has been ordinarily resident in the territory for at least 10 years. D is in there, but with provisions, with qualifications on it. The person must be vested in the territory in the form of ownership of property and all the rest of it. In this particular bill, Madam Speaker, those provisions have been removed completely, and just asking you to be a resident ordinarily for 10 years or more in the territory. B, also, Madam Speaker, where it speaks of holds a certificate of residence under Section 18 of the Immigration and Passport Act. That's another relaxation from the current bill. Madam Speaker, I asked myself the question as to why. What's the problem? And the answer that came back is that the jury pool is too small. They're having difficulties finding people to sit as jurors. And when you scrutinize the reason, Madam Speaker, you then ask yourself the question as to, well, whose fault is it? I'll give you two reasons, Madam Speaker, why that bothers me. Two reasons. Of the many categories of persons who are eligible to stand as jurors currently, it seems to me as if, well, this is reality, only one particular category is being pursued, one, and those are the persons who are registered to vote, which would be C on this list, is listed on the Register of Voters prepared under Section 23 of the Elections Act. Those are the only people currently being pursued, people who are registered to vote. Despite the option of including others, simply belongers. There are a number of belongers in the territory, Madam Speaker, who are eligible to vote, and eligible to serve as jurors, but they're not registered to vote. So they never get called. Never. And then there are people who go around asking the question, are you registered to vote? And they say no. And this is probably a reason they're not registering. Probably one of the reasons they're not registering to vote, because they know if they register to vote, if they don't register to vote, they'll never get called to serve as jurors. So, Madam Speaker, I asked the question. I said, I'm hearing now that the pool that has been created is too small. It's small. And when you look at the persons who are being exempt from serving as jurors, you start asking yourself the question, are they serious? Do they really want persons to serve with all these disqualifications and exemptions? Let's look at the disqualifications, Madam Speaker. And I'll get back to the pool, the creation of the pool, because that's the crux of the matter, Madam Speaker. Under Part 3, Section 6, Clause 6, 1, disqualification. The following persons are disqualified from serving as jurors. A person who is unable to speak, read, and write English. A person who is unable to speak, read, and write English. Well, I trust that those are not belongers or naturalized citizens or whatever they are. A person who is unable to speak, read, B, a person who has a physical or mental condition which impairs that person's capacity or ability to conveniently and fully discharge the duties of a juror. No problem there. C, a person who has been convicted of an offense for which that person has been sentenced to imprisonment for 12 months or more, unless that person has received a free pardon in respect of the sentence. Help me to understand that, Madam Speaker. A person who has been convicted of an offense for which that person has been sentenced to imprisonment for 12 months or more, unless that person has received a free pardon in respect of the sentence. So, Madam Speaker, you're telling me that a person who has been convicted and served a 12-year sentence, a 12-month sentence in 2000 or 1992 or whatever the case might be, has lost their eligibility to serve as a juror for life. They can't serve today based on this bill. Once convicted, always convicted, can't serve as a juror. D, a person having bad character or currently before the court in a criminal proceeding. Or E, a person who is a judge or otherwise declared bankrupt. This thing about bankruptcy seems to be a crime, Madam Speaker. No matter where you turn, how you turn, if you're bankrupt, you can't do anything. It's just a person who somehow failed in their business. Why is bankruptcy being treated as such a big crime? Can't run for public office if you're bankrupt. Somebody what needs to explain to me what this stigma is all about when it comes to bankruptcy. Big corporations are filing for bankruptcy and they have tons of employees, but yet they're bankrupt. in Chapter 11. So if bankruptcy is such a bad thing, it should be treated as a criminal thing, equivalent to a guy who went to prison for 12 months. But yet, people are working for the firm. Something can't be right. For the purposes of subsection 1D, bad character in reference to a person means a person who has evidence of a disposition towards misconduct. Bad character. In reference to a person means a person who has evidence of a disposition towards misconduct. Madam Speaker, something like that is so subjective that you can just look at people and disqualify them, and you don't have to give any explanation. So no wonder they have a problem, they're having a problem using the limited option, the single option, looking for people. No wonder they have so much problem. So you're going to juror list, madam. You're going to voter registration list, looking for people to serve as jurors. And they're being disqualified to serve as jurors, but yet they can vote. They can vote. They can vote for the same people who's going to make the law to determine whether or not they can serve as jurors. You see, Madam Speaker, the chicken and the egg scenario here? Exemption from juror service. This is 7. 1. Persons specified in Schedule 1 are exempt from serving as jurors, and their names shall not be inserted in the jurors' register. 2. Where a person's name who is specified in Schedule 1 appears on the jurors' register, that person shall notify the registrar and claim an exemption. 3. The Cabinet may, by an order published in the Gazette and subject to negative resolution of the House of Assembly, amend Schedule 1. Madam Speaker, that is really funny. Okay, if they want to amend Schedule 1, the Cabinet wants to amend Schedule 1, but it must come to the House of Assembly for a negative resolution. I think this, if it's that important, Madam Speaker, it should be a positive resolution as opposed to a negative resolution. But here's what Schedule 1 is asking. These are the people who are exempt from jury service. 1, the governor and his or her spouse. 2, a member of the Cabinet and his or her spouse. I want you to count them, Madam Speaker. And when you're done, tell me who you got left. Taking into consideration that the people who are creating this pool are using a single source, which is the voter registration list. 3, the deputy governor and his or her spouse. 4, the cabinet secretary and his or her spouse. 5, a member of the House of Assembly and his or her spouse. That's 13 and 30, that's 26 people right there. 6, the clerk of the House of Assembly. 7, a judicial office holder and his or her spouse. Now, I don't know what a judicial office holder is. Who classifies these people as being an office holder? 8, the director of public prosecution, counsel and administrative staff in the office of the director of public prosecution, his or her spouse, parents, siblings, and children. That's 100 people or so right there. 9, an attorney at law, barrister, or solicitor in government or private practice. 10, an officer of the courts of law. 11, the staff of the registry of the Supreme Court. 12, the staff of the magistrates court. 13, a police officer and his or her spouse. 14, a prison officer and his or her spouse. 15, a medical practitioner, nurse, and other medical staff in active practice of the Dr. D. Orlando Smith Hospital or any other government medical clinic of the territory. 16, critical or essential service staff certified by the respective heads of the following institutions: Fire and Rescue, Water and Sewage, BVI Electricity Corporation, Air Traffic Controllers, BVI Airports Authority, and BVI Airport Security. 17, a licensed minister of religion. 18, school teachers in active practice. 19, the Auditor General. 20, Accountant General. 21, Director of Internal Audit. Madam Speaker, that's a list. That's a 21 numbered list. Some of those numbers, as I mentioned, as I was reading it, some of those items could go up to, at least in the House of Assembly, you're talking about 26. Some of them could go up maybe to 100. That's a disqualification, Madam Speaker. If you're going to disqualify so many people from so many categories, it is easy for someone to come back and tell you that they want to broaden the pool from which jurors are selected. Madam Speaker, a quick analysis from what I see, just by using the voter registration list, Madam Speaker. Each district in this territory is good for a good 1,500 people registered, a good 1,500 people. And if you take all 9 districts, you're coming up with something like 13,500 people. 13,500 people. And there are other nuances about who can serve as jurors. If you can't serve within 2 years of service and all that stuff. And there are other people who get disqualified. But I ask a question, even using that narrow pool, Madam Speaker, of 13,000 of the voting registration list, you have an enormous amount of people on that list, Madam Speaker. Like I said, it's like 13,500. And from that 13,500, you're telling me still that you're having problems with your pool for the jury. I have an issue with that, Madam Speaker. But I'll go a few steps further. Why are we not using category A that says belongers? Why are we not looking at all the belongers in the territory and selecting from that pool? Granted that many of the belongers are registered voters, but there are many who are not registered voters, and they never get called. Before we just look at this bill before us and approve it or pass it based on a request that's been made, we need to ensure that persons who are charged with the responsibility of creating the pool are exhausting the categories that are available to them before we go ahead and start thinking about increasing the pool, or adding categories, or diluting the requirements for particular categories. That's our job. Madam Speaker, I said to members of this honorable House that we are the ones who makes the laws. The laws are made by us. Anything else that comes before us is our recommendations for laws. And if someone makes recommendations, we need only ask them, well, why is this being done this way? And if you can't satisfy me that you have a good reason for it being done that way, then it can't be done. We shouldn't do it. And I am not convinced, Madam Speaker, that we are using all the tools that are available to us currently. I'm not convinced. Until someone shows me that every single belonger who are eligible to be a juror is being looked at and placed in a pool, and not just those who are registered to vote, I am not convinced that we need to do anything, add some of these categories that they're asking us to add. They're asking us to add persons who hold certificate of residence. Just simply holding a certificate of residence and being between the ages of 18 and 70, you are eligible to be a juror, save for the exemptions that are in the bill. I do not, Madam Speaker, and I will say it again, I do not agree with that. Places that I know of, in order to be a juror, you need to be a citizen of the country. Someone will point to the United Kingdom and say you don't have to be a citizen to be a juror, but I would quickly point out to them that you have to be registered to vote. There are a slew of conditions, Madam Speaker. A slew of conditions, but this came with no conditions whatsoever. I cannot agree to that, Madam Speaker. And D on this list asks that has been ordinarily resident in the territory for at least 10 years. That's a total no-no, Madam Speaker. Someone will point out that under the old act, under the current legislation, that's the case. But no, it's not the case. There are conditions attached, which have been removed for this purpose now under this proposed bill. Madam Speaker, we're going down a slippery slope. And the last time I checked, brakes can't help you. So let's not take that track down the road, that slippery slope, Madam Speaker. Brakes can't help you. If we're going to do anything, let's do it right. Like I said, if every single belonger in this territory is being placed, who are eligible to be jurors, are being placed in that pool, it would not only be 13,500, maybe it'll be 16,000 people, 17,000 people, maybe 18,000 people. We don't know. But I know it'll be a whole lot more than it is today. I am being told, Madam Speaker, that the pool as it is today, after all the exemptions, the disqualifications and what have you, it's a little over 1,000 people. Just a little over 1,000. Well, if it's a little over 1,000, I just told you that the registered voters are 13,500. What happened to the other 12,000 people, Madam Speaker? You mean all those people are ineligible based on the exemptions? 12,000 people to be jurors? Madam Speaker, in that particular regard, I am recommending that we put in place what can be referred to a jury pool board. And it becomes the responsibility of that board, Madam Speaker, to create the pool, We have a board for immigration that determines who should and should not become belongers and hold certificate of residence. We can do that. I don't believe, Madam Speaker, that as it now stands, the persons who are responsible for creating the pool has the time to do it. But there are other things to do. This could be time consuming if done right. This doesn't seem to me to be a priority job. And I think it should be assigned to someone, a board, whose priority it is to create the pool. I see nothing wrong with doing that, Madam Speaker. If we are looking to do things right, if we are looking to get our desired results, let's do what it takes to get it. The Registrar of the Supreme Court, I would imagine, Madam Speaker, has a whole lot of other things to do. That should not include the mundane task of combing through a voter registration list, or combing through the Immigration and Naturalization Passport Act to see who has belonger status, and then filtering it to see who should be disqualified. I don't think that that's a role for the Registrar of the Supreme Court. Everything else we do has a board or a commission for the purpose. If this has reached to the stage now where it has to come back to us asking us to broaden the pool by adding categories, which I don't believe we need, then it's the responsibility of this House to come up with solutions. And I think that's a fundamental solution that I could point my finger to, and anyone who's looking at this objectively can point to and say, well, there you go. We can make it work this way. Another thing, Madam Speaker, that I personally am prepared to look at and accept, most likely, in order to broaden this pool, is that naturalized citizens be added to the category. Add a category for naturalized citizens. Because as you know, Madam Speaker, you don't have to be a belonger to be naturalized. Once you have a certificate of residence, you're eligible for naturalization. If we add that category, Madam Speaker, at least what it shows is that the persons who have a certificate of residence has intentions to expand their status in the territory, that someday they too will become belongers and someday too will end up on the voter registration list. But you have people in this territory, Madam Speaker, who has residency. For years, 20, 30, 40 years, they have no intention of becoming belongers. They're satisfied with that. So why embolden them further? By allowing them to become jurors, and then the next thing you know, you want to put them on some welfare list and all the rest of it. No, Madam Speaker. You want to be in the territory. You should do all the things that are necessary to make you a full-fledged citizen of the territory, meaning being able to vote someday, meaning being able to purchase land without having to get a non-belonger landholding license. We should be encouraging people to take these steps, not emboldening them to stay where they are and do what they feel like doing. So, Madam Speaker, I am prepared to entertain the addition of a category of naturalized citizens as part of the pool from which jurors can be extracted. So, Madam Speaker, as far as I am concerned, I think I have no further problems with this, but I think that, and Madam Speaker, just for for the record, let me just read into the record. Let me just read into the record as to support those people who are having difficulties with the pool as it is, and just to show some of the things that are not correct or should be looked at. It says certain persons not to be summoned. Subject to section, this is 17, Madam Speaker, in part 5 of the bill. Subject to subsection 2, the registrar shall not summon a person, A, who is known and believed by the registrar to be temporarily absent from the territory and not likely to return in time to attend the sitting of the court. Don't ask me how the registrar will know that. B, who has within 2 years prior to the present selection been selected and summoned to serve on a jury panel from the jurors register in accordance with section 15(1). Are all these limits necessary, Madam Speaker? Whose consideration is being taken here into account? The employer or the individual? Why a person who has served, a person who has within 2 years prior to the present selection being selected and summoned to serve on a jury panel from the jurors register in accordance with section 15(1). That person can't serve. You can't serve within 2 years. C, who to the best of his or her knowledge, information, and behalf is currently employed at the same place of business from which a juror has already been summoned. Just check this one, Madam Speaker. Who to the best of his or her knowledge, information and belief is currently employed at the same place of business from which a juror has already been summoned. Now, Madam Speaker, work with me on this one. A guy working at Jay's Delivery Services with 3 employees has an individual already selected as a juror, shouldn't have a second one, which would bring his employment pool, which would diminish his employment pool by 60%. Should not have a second one selected from the pool, from to the pool from his office. I can understand that. 3 employees. You got one already, you can't get a second. But let's go to someone like Right Way, Rotan Wholesale. With hundreds of employees, you tell me only one person could serve from that particular establishment? Madam Speaker, am I misinterpreting something here? It can't be right. So no wonder there's no one left to serve. These are the kind of things, if what I'm seeing is correct, if what my understanding is correct, something isn't right. D, who is a spouse of a juror who has already been summoned for the same sitting of the court. Okay. Notwithstanding subsection 1C, A, where the number of persons employed in the same place of business exceeds 8, where the number of persons employed in the same place of business exceeds 8, the registrar may summon up to 1/3 of the number of persons so employed at the time. Okay, so that satisfied my curiosity. You can summon up to 1/3 of the number of persons as long as the number of employees exceed 8. And B, where 2 or more businesses are carried on by or on behalf of or for the benefit of the same employer or employers at a particular place of business or at different places, the fact that a person is employed in one of the businesses has been summoned to serve as a juror shall not excuse another person employed in any of the other businesses from being summoned. The decision of the registrar as to whether or not 2 or more jurors are employed in the same business shall, for the purposes of this section, be final. No problems with that, Madam Speaker. Madam Speaker, that's my position on this bill, and I would implore other members of the House to offer their views and take into consideration, Madam Speaker, what is in the best interest of the territory. Thank you, Madam Speaker.
Thank you, Leader of the Opposition. Any other member wish to debate? I call on the Junior Minister for Trade and Economic Development.
Thank you, Madam Speaker. The Jury Act is a very important piece of legislation. It is important, Madam Speaker, that persons are able to go into a court of law and be able to feel comfortable when they meet maybe an unfortunate circumstance, but that they feel comfortable that they will be given a fair trial. Madam Speaker, it is also very concerning to me that we're speaking about trials without juries, but I think we're at a crossroad here, and we're debating this bill today without much public consultation, Madam Speaker. And I am very concerned about that. And I know, Madam Speaker, that certain individuals may not be happy that I am saying this today. However, we're debating to take something out of a bill, which is where most persons are not comfortable with a trial without a jury. But here we are, Madam Speaker, doing the same thing to the public. In discussions about this bill, Madam Speaker, I have been told that there were public consultations in 2009, some 13 years ago, Madam Speaker. I believe the year is correct. I have asked to be provided, Madam Speaker, with information. I've asked for proof that these consultations were held, dates, venues, and times. Madam Speaker, before being elected, like my mother would say, I am there when every pan knock, and that's not to go to a jam alone. Every public meeting, I make myself available, and I simply do not remember public consultations on this bill, and I've asked for the proof, and I have not received it. Madam Speaker, on the 3rd of October, at about 12:19 p.m., I got a notification in one of the chats that I was in that showed a Zoom meeting to be held at 6 p.m. on that very day. Madam Speaker, it disturbed me because the timing, less than 6 hours notice, with the House to convene on the next day to look at this bill. Me being the person that I am, I made it my business, Madam Speaker, to tune into that Zoom meeting. And what really made me realize, Madam Speaker, that this bill was being rushed through without due consideration to the public was when a young man asked a question on the Zoom about what is bad character, what's the definition. And in my opinion, he was basically brushed off. That young man in 2009 would have been about 7 years old, Madam Speaker. So if there were meetings held, public consultations held in 2009, 13 years ago, Madam Speaker, we can do the math. Honorable Fraser gave mention of so many people that should be in this jury pool. How many of those persons from 2009, 10, 11, 12, all the way up to 2022 are now 18 years or older that did not have the advantage of these public meetings that apparently were held in 2009, but I have been unable to be furnished with the proof that that was the case. And so we've left out a significant portion of our population who might be interested in serving on the jury, Madam Speaker, but has not been given the privilege of the public consultations but for one Zoom meeting. In 13 years, and I am not one to lay blame, but I am asking that this not continue to put persons at a disadvantage, because the Deputy Governor's Office, who's responsible for putting this bill out to the public, did not do so in a timely manner. We have to call a spade, and all of those hundreds of persons who made 18 or who registered to vote since 2009 did not have the opportunity. We're talking about the sister islands as well, Madam Speaker, where it is mainly tourism-based, and while we might be in the slow season, persons are preparing. There are persons that are out there walking that may not have seen that notice for that Zoom meeting until it was long past. No adequate notice. And I'm very disturbed by that, Madam Speaker. Yes, when we go into committee, I will fight vigorously for the rights of those individuals as well as the entire population. But how many times are we going to do this, Madam Speaker? It happened with the Register of Interest Act, where we got it the very morning we were coming in here. Where did that bill come from? Who wrote it? Why did we not see that before? And Madam Speaker, I am thankful to Honorable Malone that he accepted me on his page, because I might not have seen it. At 12:19 on the 3rd of October, for a meeting at 6 p.m. on the 3rd of October, Madam Speaker, coming from the Deputy Governor's Office, It is unacceptable. We continue to produce these sort of situations that puts us in a bad position. And we're in a debate, and I welcome the debate, but for me, Madam Speaker, the public needs to be able to voice their opinions on such important matters. Last week, we were out in the field making sure that persons understand what is happening with the Liquor License Act. Who's responsible for ensuring that the public understands what's going on with the Jury Act? One meeting for 13 years is unacceptable, and now we're being asked today to come to this house, this honorable house, to vote on this bill without the benefit of public consultation. There are so many persons out there that might have a recommendation that none of us in this room might have. And for some strange reason, this continues to happen. It is not right, and I know that I will take some heat, but guess what? That's why I was put here. Because I am not representing myself, I'm representing the people, and the people need to have a say when we come here in this house. And Madam Speaker, I want to go back to the committee stage, because we will go into committee stage and we will argue, we will bring our points across. The public does not hear that. They don't see that. But they are not being given an opportunity to be able to have a say. And this could never be an emergency situation. And I understand, Madam Speaker, that these things do happen. Emergencies happen. But from 2009, and it was said over and over to me, it's been here from 2009, and we have to get it passed, Madam Speaker. What type of emergency is that for 13 years? And our young people haven't had the benefit of being able to understand and to ask the questions that they need to ask. And so Madam Speaker, I am a little perturbed, to be honest, because we can't just do things because somebody else put a deadline on it. From 2009, that was 10 years before I was elected, 10 years within that gap. And now it is expected that we're supposed to just rush it through because somebody put a deadline on it. Now, and I respect deadlines, but we have to understand that we need to give the public that opportunity, because we're not in here working for ourselves. And I would implore every ministry, the Deputy Governor's Office, whoever is bringing these bills to the House, do not come with any last-minute things at all that don't constitute an emergency, because I will be getting up again and saying the same things, maybe not in the same chronological order, but I will be getting up. So I am putting y'all on guard. It needs to stop, because we, the members of the House of Assembly, we get the blame. We get the blame in here because the people don't have anybody else to turn to. So don't make something that you didn't do an emergency and come to this house and tell us you need to pass this because we miss our deadline. It is wrong. It is wrong. I've seen it happen too many times, Madam Speaker, and it needs to be rectified. and the blame needs to be put where it needs to go to. And there's no excuse that that document for 13 years, you're coming now and telling us pass it, because we have to meet a deadline. And the public, again, did not get a fair opportunity. And we're in here now putting a document together for somebody who might have committed a crime. We want to make sure, or there's some legal civil matter in the court, we want to make sure that those persons are treated fairly. But the same general public, the same jury pool that we're looking to put together has not gotten the opportunity to understand what they are going to get themselves into, because if they get a summons to become a juror, there are consequences. And so you're now not educating the very public that needs to know what they need to do, or if they even qualify. And if they qualify, they need to understand what their role is if they have to become a juror. So, Madam Speaker, I will end here, but I will reiterate, public consultations are important. One Zoom meeting cannot work for a territory of 60+ islands, albeit some of them are not inhabited. But we cannot use that as an excuse and have one meeting online, 6 hours notice when you had 13 years to do these public consultations, and with persons who couldn't even vote. They were 5 years old, 7 years old at the time, who maybe couldn't even spell the word jury at that time. And now you're asking those persons to just accept it without having an opportunity to understand what it is happening. And you're turning around and asking us to pass this thing in here, with knowing that the public has not gotten the full benefit of understanding what is written here in this bill. We have to be fair, Madam Speaker, and we have to be truthful. We have to have that integrity that we should not place the people of this territory in a position where they're not understanding what is in this bill. We have a responsibility to make sure that happens. And before I sit, yes, we go into the committee stage, which persons won't see on camera. And we will fight to make sure that the public and anybody who might end up being on a jury has a fair chance to understand what is really going on. And I really wanted to pinpoint something Honorable Fraser said too, where you have multiple persons from one business being called to serve on the jury. And that has happened. And you know, it might not happen to those big businesses, but I know for a fact that it has happened where you have 5 and 7 persons from the same business place being called, or from government entities as well, being called to serve at the same time. And in such a small community, due diligence should be practiced, because I am sure that it would show when you get that list where these persons work, so that you don't inconvenience businesses, or some businesses having to close down, because it is the civic duty, and when you get a summons, you must obey that summons. So, Madam Speaker, once again, I thank you for the opportunity to be able to debate this bill, and I will remind everyone who's responsible for making sure that public consultations are held, adequate public consultations are held, to do their part, do your job, make sure that it happens. Don't shove anything down the public's throat at the last minute. Thank you, Madam Speaker.
Thank you, Honorable Member. I call on the Premier.
Thank you, Madam Speaker. I just want to raise on a point of information, just for the benefit of the public. I certainly don't think it was a member's intention, but I just want to make sure it's clear that the public understands that this bill does not deal with juryless trials. That's not something dealt with in this bill. I just want to make it sure it's absolutely clear, Madam Speaker, for the public, so no one in the media or anybody else gets confused. Just point of information, this bill does not deal with juryless trials. That's not the subject of this bill. Thank you, Madam Speaker.
Thank you. I call on the Junior Minister for Trade.
Thank you, Madam Speaker. If everyone listened to the context of what I said, I did say it is something that was being considered. I didn't say that it was in the bill, but it was out there in the atmosphere. And I believe I saw it. It was bandied about within the COI recommendations. So be that as it may, the last minute production of giving the public as well as members of this honorable house these documents, it has to stop. It has to stop, Madam Speaker, because we cannot represent the public properly if we don't have the tools to work with. And I really would like a few more minutes, Madam Speaker, to say that when we get these type of documents, they are written in legal terms. So, yes, I might have 2 degrees, but I cannot read and understand a 29-page document fully in an hour. I need to be able to read it over and over, understanding it, get to ask the questions that I need to ask to be able to represent the public. The public also needs the same opportunity that the members are...
Honorable Member, I'm sorry, I don't mean to interrupt, but I know we did allow the opportunity before for you to fully debate, and so...
I'm not hearing you.
I said, I'm sorry to interrupt, but I know you did have the opportunity to debate the matter, and I assume that when you asked to rise again, it was only to just clarify that position based on what the Honorable Premier mentioned in terms of his point of information.
Thank you, Madam Speaker, and I will sit now. I am sure that the public understands very well what I have said and where I am coming from. We need to be diligent and on time when we bring these documents to the public, and again, not shove them down people's throat. Thank you, Madam Speaker.
Thank you, Honorable Member. If there are no other members that wish to debate at this time, I will call on the Premier. Honorable Premier, before you rise, is this to...
Point of information, Madam Speaker. I just want to be clear. I don't want anybody in the public to think that I'm contradicting the member, because I'm not. I'm just seeking to provide some clarity, mainly for the public. The subject of juryless trials came up in the COI. There were 2 recommendations that consideration be given to expanding the jury pool and consideration be given to juryless trials. That came up in the COI. But that was not being considered for this bill.
Thank you, Honorable Premier.
I just want to make sure that clarification for the public. And certainly no one should think that I'm contradicting the member at all. I just want to ensure that the public has accurate and all the information. Thank you.
Thank you, Honorable Premier. I call on the Deputy Speaker, Honorable Neville Smith.
Go. Madam Speaker, I rise to support this bill. Madam Speaker, there's a few things in the bill that we may need to speak about which in committee stage. But with reading the old bill and reading this one, I've learned that it's basically the same bill. Just a few changes were made. It seemed as if to change up the wordings. And it is clear that the bill is just to expand on a jurors list, the amount of people we get, Madam Speaker. So yes, there's a few things, and I support the Honorable Leader of Opposition with a few remarks that he made. One of them was to maybe find a board to help choosing the jurors. So I do support that as well. But Madam Speaker, I want to bring something in the open as well. We talk about expanding the jurors list. But one of the things that concerns me the most is when we do this, we also open up a room for more people to be a part of this jurors list. But there's something called blogs, the bloggers. And I'm wondering how will we control that with a juror list, where we don't know who these jurors are, we don't know who are blogging, so we don't know who the jurors will be, and they might be still blogging, and they're sitting on a case. That's one thing I would like to bring up during the committee stage, to see how we could tackle something like that, because I think it will be a problem where you have a juror who is a blogger, who's not using his real name, but sits on a case and is blogging, Madam Speaker. So that's one thing I'd like to bring up during the committee stage. Other than that, Madam Speaker, as I said, I think a lot of work went into this bill. Like I said, I read the old one, and I read the new one. I actually made it my business sitting at my desk for 2-3 days going through this bill. And reading it, you can see that the wording has just, some of the words have just changed up, but everything more or less the same. Madam Speaker, with that, I'll take my seat. Thank you.
Thank you. Deputy Speaker, I call on the member for the 9th District.
Thank you, Madam Speaker. Thank you for the opportunity to say a few words on this jury bill. That is one of the cornerstones of any democracy, is having a fair and equitable justice system. And Madam Speaker, the member for the 3rd covered most of what I would have said, but a few things I would like to point out. The first one, Madam Speaker, is in the qualifications in part 3, where A is a belonger, there's no particular issue there. B holds certificate of residency under Section 18 of the Immigration and Passport Act, revised edition 2013, no issue there. C is listed on the register of voters prepared under Section 23 of the Elections Act, revised edition 2013. Or D, has been ordinarily resident in a territory for at least 10 years. Madam Speaker, I'll bring this up more in committee stage, but I would like to see D be amended a bit to include a few other qualifications than simply just being in territory for at least 10 years. Maybe property qualifications and so forth. Yes, Madam Speaker, I fully appreciate the need, based on our discussions we had previously, to expand the jury pool. And I think it came across in one of the discussions that if we fail to expand the current jury pool, it may lead to juryless cases, which none of us really want. So I think it's in all of our best interest to do the best we can to get a pool expanded, because the idea of trial among your peers is very, very important. And Madam Speaker, I'm one of 2 members in here who represent islands outside of Tortola with significant populations. So it does concern me how this here affects Sister Islands residents, so to speak. And I look at the first one is the exemption schedule. This is on page 23. And if you go through that schedule, you see most of it, as it stands now, and as the trends are, affect the Sister Islands differently to it would Tortola, the governor or his or her spouse. I wouldn't go through every single one. But is a governor likely to ever be living on a Sister Islands? It was so many years ago, Governor Pickering lived in Ghana. Will it happen again? I guess it's left to be seen. A member of cabinet and his or her spouse. Again, very limited numbers. The cabinet secretary. The one that concerns me is police officers. The last time I checked, I think the entire police force in the BVI was about 345. So, and their spouses, Virginia has about 28. When you get a smaller population, this can significantly affect persons being represented by their peers. And Madam Speaker, that concerns me. But we'll dig into that a little more in the committee stage. And then we get to the rules of payment. Madam Speaker, everybody knows that traveling from a Sister Islands to any activity on the mainland can be expensive. The further away you are, the more expensive it can be. And if you get section 42, number 2, the fees under subsection 1 may include compensation for a loss of time and expenses paid or incurred in going to, attending at, or returning from the court. There are no courts on Virgin Gorda, on Anegada, sorry. The one in Virgin Gorda, I'm not even sure it's functional. I've heard various stories, if it's functional or not. So automatically, those 2 islands there, are going to have to incur significant expense. Because it didn't say exactly when the fees were to be paid, if you get these things before or after. If you ask someone to travel many times from Anegada to attend court, that person may rack up significant expenses just to attend court. And I think that would be unfair if it's done afterwards. And the same thing will apply to Virgin Gorda. And then penalization of jurors prohibited. And I go to 43B. Fees to a juror under this act or rules made under section 42 shall be the personal property of the juror. Then it goes on to number 2B. Deduct any sum, an employer of a person who is serving, has served or is qualified to serve as a juror under this act shall not B. Deduct any sum from the salary, allowances, emoluments, pension, gratuity, benefits or other remuneration of that person on account of the fact that that person is serving, has served, or is qualified to serve on a juror. Madam Speaker, it was mentioned earlier, but this has a significant impact, particularly on small businesses. The number of businesses in the BVI, particularly in Sister Islands, they really have only 1 or 2 or sometimes 3 employees. Sometimes 1. If you are telling that employer, essentially you're closing the person's business down. You're telling this employer, I'm taking your 1 or 2 employees from your business, but you must pay them still, as if they were there. You're not receiving any benefit from that person, but you must pay them their salary as if they were still working. And Speaker, as cause for concern, when you consider that on the Sister Islands, they're mainly tourism industry, and persons only make money particular times of the year. So imagine being a slow, dead summer. You aren't making any money, your employee is called to be a juror, and you have to pay when you yourself is not making any kind of money. Madam Speaker, we have to figure out how we're going to massage this to where it doesn't adversely affect the tourist economies of the BVI, which are mainly on the Sister Islands. And then we have failure to attend, which is on the other page, on page 44. Again, there needs to be some kind of a caveat in there. A person's duly summoned to attend as a juror at an institute of the court who does not attend, blah, 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 may be fined. Again, Madam Speaker, we have to be considerate of persons on the Sister Islands who may be serving during adverse weather conditions. Yes, you may say, well, maybe the person needs to call, but what if there's no way of getting the message across that due to these particular conditions here, I am unable to attend? Madam Speaker, I look forward to addressing this here in committee stage, as again, we have to make sure that when we are making these laws, they apply as equally across the entire territory as they can. Madam Speaker, the member for the third raised the possibility of maybe including naturalized persons, and he's absolutely correct. Okay, you may be resident, not a belonger, not a voter, but you are naturalized. And I can't say exactly what that number is, but I do imagine it's probably in the hundreds, if not thousands, at this point in time. Even though I believe if they're resident, they may already be captured on this schedule. Madam Speaker, I don't think any of us in here would like to see juryless cases, judge-only cases. So again, I think it's in our best interest that we get this Jury Act passed in the best way that does not affect us negatively going forward. Thank you, Madam Speaker.
Thank you. I call on the territorial at-large member, Honorable Carvin Malone.
Speaker, I thank you kindly for allowing me the opportunity to lend a few remarks in regards to the Jury Act 2022. As usual, I'd like to go somewhat to the root of some of these issues so we have a clear understanding of what we are looking at. Section 52 of the Act, Madam Speaker, states that it repeals Cap 36, the Jury Act of 1914. Now, in the research, and I was ably assisted, that act itself was amended by Act 21 of 1994 and by Act number 5 of 2005. So a 1914 Act is what we are dealing with, save for amendments made. I didn't get to go through how substantive the amendments were in 1994 and 2005, but I informed that in 2013 there was a compilation of all of these pieces that makes up Cap 36. So Cap 36 is now being repealed, which is great. We also learned that in 2009, from 2009, as some members have stated, we've been trying to get the Cap 36 repealed so that we can modernize and we can bring into effect a new Jury Act. I am one who basically pushes for the proper order in terms of first reading, and then you have time to do public consultation, and then you have the second and third readings. I do not recall exactly when the first reading of the Jury Act was placed in this House, and I could be informed later as to exactly when the first reading come. But as I've stated before, I'll state again, we have to reach to the point, and this is why I have now gotten into the habit of once a first reading is out and it could be shared, I try to use my information page, of which members have benefited from, to send it out, because I think it is critical that the general public continue to be informed and to participate in all aspects of information dissemination, receiving information and participating in any of the areas of importance to the general public. So it is critical that we do this. Madam Speaker, we are or should be aware that the role of the jury is to provide unbiased views or resolution to evidence presented in a case in a court of law. Jury service helps to support fairness in trials. jury service is able to give impartial viewpoints on cases that are presented in court. Madam Speaker, before I continue that, we just want to look at Section 53 because just so the general public can get a feel for what is being done here. Section 53 reads in 1, the jurors or the allowances, the rules that were revised in the edition 2013 shall, until revoked, continue to be in force to the extent that the rules are not inconsistent with the Act. 53.2 states that notwithstanding the repeal of the Jury Act under Section 52, the voters' list, revised as of 29th December 2021, shall, on the commencement of this Act, be deemed and construed for the purposes of this Act as a jurors' list until a jurors' list is compiled in accordance with Part 4 of this Act. And number 3, it states that notwithstanding the repeal of the Jury Act under Section 52, a jury panel existing prior to the commencement of this Act shall, on the commencement of this Act, be deemed to have been construed under this Act. I think that is very important for all persons in the court system so that there's an understanding as to exactly when this comes into effect and what will be in place between now and when it comes into effect so that no one is misunderstood as to exactly where we are. So we have the role of the jury, and there are two things I want to read only because they bear relevance to the Jury Act. In England and Wales, in my research, which have the same legal system, everyone accused of an offense which carries more than 6 months imprisonment has the right to trial by jury. Minor or summary criminal cases are heard without a jury in the magistrate's court. If I'm incorrect here, I think the Attorney General will assist in correcting that if that is wrong. In the United States of America, the American jury trial is a constitutional right. The Founding Fathers believed that the right to be tried by a jury of your peers was so important that it merited inclusion in the highest law of the land. I might stick a pin here and say that I was searching through our Constitution to see if a trial by a jury was embedded in there, and it is not. It speaks of the human rights and the rights to fair treatment by a prisoner. We'll come to that. So they find it so important that it is embedded in the highest law of the land. So in that we're doing constitutional review now, maybe it becomes important, and it will be contrary to what was suggested, as members have stated before, in the Commission of Inquiry in terms of judge-only trials, which I might support the Premier in that it is not part of what is being examined here in this particular provision. And the member did not insist that it was, but it is one of the recommendations, I think it's 43, of the particular Commission of Inquiry that states to examine judge-only trials. I questioned it when we had the informal meeting with the panel, and they were the ones who, they enlightened me that it was not part of this, because I too thought it was. Madam Speaker, I continue and says that Amendment 6 and 7 of the Bill of Rights in the U.S. contain the rights. Amendment 6, in all criminal prosecutions, the accused shall enjoy the right of a speedy is underlined and will be revisited, and public trial by an impartial jury of the state and district wherein the criminal shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him or her, to have compulsory process for obtaining witness in their favor, and to have the assistance of counsel for their defense. These are critical in first world countries, second world countries, and may I say even third world countries. In other forms of jurisdiction or laws, maybe not, because you don't need them, because we'll take care of you in another manner. Madam Speaker, in a democracy, it becomes important. And before I go through the other areas specific to the particular act, I might say that, and I say this only because when we do get, and I always revert back to this, a certain reports on which we will debate again, we will find that the courts, administration of justice, if I am not wrong, is under the governor. And this is why the Premier says that this too is an act or a responsibility, although he is charged with bringing it to the House, is that of the governor. Am I correct? Premier? He is reading. But, Madam Speaker, the fact is that we have to be always mindful of what we are faced with, because as a territory, and I'm not going to be breaking any new grounds where this is concerned, we have too many persons detained in Her Majesty's prison awaiting trial. The concept of a speedy and public trial cannot be taken lightly. Speedy cannot mean 2 years later, 3 years later, 4 years later. Speedy can only be defined as speedy as soon as possible. We have, Madam Speaker, to do better and bring this to the doorsteps of those in charge of making sure that this happens. This is one of the areas that the Commission of Inquiry should have highlighted first. It is one of the items that is embedded in the other report of which we must get. Because if we're going to do this right, we have to be right by everyone, not only those who have the money to afford it, but those who may have fallen on hard times. They don't have the money, but they have to have a public prosecutor. They have to have their cases brought up so that they can get the cases heard. We are getting in trouble as a country because of this. I will say very little now, much more later. Madam Speaker, Part 5, 9.1 is what I'll read from. Preparation of the jurors list. The registrar shall request the A, supervisor of elections, B, chief immigration officer, C, registrar general, D, labor commissioner, and E, director of social security, to provide in respect of all persons qualified under Section 5. Such information, including a person's prescribed particulars, that may assist the registrar in the selection of persons for inclusion in and the preparation of a list which shall be called the jurors list. Clear. But let's go to the section mentioned, which is Section 5. Section 5, Madam Speaker, states that subject to Sections 6 and 7, 6 deals with disqualification, and the list have been enhanced in terms of furthered from what exists in the 213 compilation. And Section 7 deals with exemption from jury service. But subject to Sections 6 and 7, a person between the ages of 18 and 70, inclusive of A, is a belonger, B, holds a certificate of residence under Section 18 of the Immigration and Passport Act, Revised Edition 2013, C, is listed on the Registry of Voters prepared under Section 23 of the Elections Act, Revised Edition 2013, or D, has been ordinarily resident in the territory for at least 10 years. And those persons, if passed by this House, is qualified and eligible to serve as a juror for the trial and determination of any criminal or civil proceedings before court. Let's go to 5A, B, C, and D. They are those persons who, although becoming a belonger, for whatever the reason or purpose, they did not get registered on the voters list. And as a result, right now, I think, under the current version, Cap 36, it does not allow those persons, although belongers, because not registered as voters, to be considered as jurors. I would say, and I will support, once a person becomes a belonger, they then should be and could be considered in the jury pool. I will also support C. It exists already, listed on the Register of Voters, prepared under Section 23 of the Elections Act, Revised Edition 2013. I will not support B, persons only holding a certificate of residence under Section 18 of the Immigration and Passport Act, Revised Edition 2013. And I will not support, definitely not D, only has been ordinarily resident in the territory for at least the 10-year period. Madam Speaker, I support what the leader of the opposition said in terms of between all of the belongers that I have heard that got their belongers status since 1914, since 2005, and since 2015, I am confident 2015 or, well, at least 2013 when it was compiled, I'm confident that combing through this, you would find more than even the 13,000 of which the leader of the opposition spoke about. And it is the onus will be on the registrar, supported by the supervisor of elections, supported by the chief immigration officer, supported by the registrar general, supported by the labor commissioner, and supported by the director of social security to find these persons so that they can then be amongst the lists that you send out notices to in order to consider their civic duty, civil or civic, whichever one it is, in serving as a juror. So you do not have to go to B and you don't have to go to D because it is not fundamentally practiced anywhere else. When I asked the question, where's the precedence throughout the world in this? I was told, well, this is the BVI of which we speak. So we can be the first. Well, I did remark, I don't want to be the first in everything. And I surely don't want to be the first in this. A jury of your peers means just that. And those who have been issued belongers status, then are entitled, as far as I am concerned, to be considered and must be considered as your peers. We have invited them, we have allowed that status to be conferred, and serving as a juror is one of those particular issues. Madam Speaker, there are many provisions, but as I was reliably informed, and I will stand to be corrected here again, I'm not sure if there's any provisions in this act. I did not get to search properly for the sequestering, is it? Sequestering of jurors. Because I know it is done, if you watch enough TV, if you were involved in courts anywhere else, you would find that the sequestration of jurors in cases where you want to make sure that the jurors are not influenced, as a member, Deputy Speaker has said, you want to make sure that they're not influenced by blogs and morning programs and evening programs, and because you have more programs here now than you can afford the time to listen to. And freedom of speech is embedded in the Constitution, and we don't want to take that away either. But when it comes to jury pools, and sequestering, there is a specific condition. I don't know if it's allowed in law. Take away your Wi-Fi, take away your radio, take away that time off you may have at your particular family, because it is critical that you're not influenced further than you may have been before being chosen as a juror. So it's an important ingredient that needs to be looked at, and I think that it should serve in this. So as we go through the committee stage, Madam Speaker, I am sure that we will look in terms of the fairness to businesses, in terms of the provision that many people speak about is whether or not a business still have to pay while you serve as a juror. I'm not sure if I'm correct by saying it seems to be universal, but whoever have to correct me will correct me. I'm not sure how we get out of that one. And the amount of monies paid, because you can't have folks being charged for being unjustly enriched, because if you're going to argue to carry up the fees to jurors and still argue that the employers must pay full pay, well, you can sign me up to be a juror today and tomorrow. 2 payments? Well, sorry, save for the fact that I'm not allowed to serve while I sit. But if I'm not sitting, then you can sign me up every trial you want. 2 payments I can take. So we have to look in terms of what is just, what is right, and what is proper. Not because we want to be the first in it, but because it's what is, if you move to, if you revoke or if you give up your status, go on another jurisdiction, would you find it there? I don't think people will choose to give up their citizenship here, serve as another, just because they don't want to serve as a juror. But we have to do what is right, what is just, what is fair, so that this sacred right of a jury by trial of your peers is never violated. Thank you very much, Speaker, for the input.
Thank you, Honorable Member. Is there any other member that wish to debate? I call on the Minister for Health, Honorable Marlon Penn.
Thank you, Madam Speaker. Madam Speaker, I thank you for the opportunity to make very brief contributions to the Virgin Islands Jury Act 2022. Madam Speaker, members have gone through at length in terms of some of the details pertaining to this particular piece of legislation and amendment. Well, simply an appeal of the existing act. Madam Speaker, I'm going to just raise a few points specific to the act and sort of gets into the crux of the actual reason, or one of the main reasons, in terms of the repeal and implementation of this act that is before us. Madam Speaker, firstly, I want to join with the Premier and first of all get out of the way publicly the notion of juryless trials that have been bantered around in the public space, that somehow this act intends to implement the issue of juryless trials in the court, in the legal system, which is not the case, Madam Speaker, and I want to thank the panel who is here today, who, when we called after the first reading, was able to answer many of the questions and concerns that were raised by members and that was raised in the public discourse, and some of the benefits or the rationale for us moving forward with this piece of legislation. Madam Speaker, the right to a fair trial, a fair and open trial is important, Madam Speaker. Free and fair trial. Madam Speaker, though I want to commend the members for their explanation, I have to agree. And this is one of those things that I've been trumpeting since I've been in this House. The importance of consultation. And I think the territorial member and Junior Minister for Trade raised that point, that it is important, particularly bills that have significant impact on the lives of individuals, lives on the society, and has impact on the business community as well. It is important for us to have the requisite and necessary consultation with those pieces of legislation. Not just with the public, but with the legislators. I've continued to say that we need to have more in-depth, informal meetings on these particular pieces of legislation, have the rationale behind in a more detailed conversation with the technocrats to be able to get a sense of the reason why we're here and the reason for making the decisions to pass these pieces of legislation. I'm going to continue to encourage us, as we did last week with the Liquor License Act, and as we would do with subsequent legislation, and the authorities that are responsible have a right, have an obligation. It should not be optional. It should not be when you feel like. It should be entrenched in the process that consultation is a must on any piece of legislation, particularly ones that have far-reaching implications like this would have on the populace. So I support my colleague in her cry, in her plea to insist in that consultation happens, and it happens more as the norm than the exception. But Madam Speaker, one of the premises in terms of having a jury is to have the defendants to have a jury that represents a cross-section of the defendant's community. And the argument that I'm hearing, particularly on Section 5, that speaks to what would make up the jury pool and what persons would make up that list of persons that would be part of the jury pool. I mean, I'm getting a little confused, Madam Speaker. Because the argument in itself suggests, based on where we're going, that the only persons that are going to be before the court of law is BVI landers or belongers. So you're then saying that only belongers or BVI landers should make up the jury pool. And I don't want to see my people before the court, nor anyone before the court of law, for a matter of fact. But if the premise of a jury trial and a fair trial is to have a cross-section of your community, we have to rethink what the cross-section of our community looks like. And we have to be mindful that our community is different. Our community is made up of a wide cross-section of individuals. And as we heard from the technocrats, the challenges that we've experienced over several trials, where trials are dismissed, trials were thrown out, persons were acquitted, because you might find later on that there's a connection with someone who was on the jury to the defendant, or someone that gave witness has some type of connection. Because there's always this thing that says there's 7 degrees of separation. In BVI, I believe the degrees of separation are even closer, to 2 or 3 degrees of separation when you look at the exemption list that is before us. God forbid I would have to go before the court, because I'm sure you'll be able to find someone to sit on that jury because of the connections that you have within the territory and within the community. And you have to be able to have some flexibility and give the courts and make sure that there's fairness in the process to ensure that persons get an opportunity to have a fair trial and have persons who can be objective in assessing and reviewing matters before the court. So I believe Section 5 is one of those areas that we're going to have very in-depth discourse on. We have to make sure that what we come up with is fair to all concerns as it relates to having a jury of one's peers or a cross-section of the community that reflects the true nature of what the community looks like and what that dynamics would look like. I think our intent is not to be restrictive or to be prejudiced to certain sections of a community, but we have to make sure that we have to strike that right balance in terms of the approach. Madam Speaker, and we also have to ensure that we get these things done because it is important. I think the territorial member raised the point, and it's a point that I listed to raise, the issue of persons on remand in Her Majesty's prison, persons who have not been given the opportunity to the right to a speedy trial, right to getting a trial done. I mean, I asked the questions, I think it was 2 years ago while I was in opposition, concerning the number of persons that are on remand at Her Majesty's prison. I think one of the longest cases was over 2 years, where someone has been on remand awaiting trial. And there's some of the instances that were listed in terms of persons that were on remand are offenses that if we had systems in place, we could have had use of technology. All around the world, persons are using tracking systems, global tracking systems, where persons are on house arrest. So instead of having a boarding on a system to pay for someone on remand, and that person themselves have to deal with the stigma of being on remand for over a year at Her Majesty's prison, and might be very well innocent of what they're being accused of, but has spent a year in prison or 2 years in prison. Who would give that person back the 2 years that they've lost? It opens up the government as well for liability and suit for having persons on remand for that period of time. So if this process, as I was understand, once we get the right framework in place, would help to move that process along in terms of trials and give persons the opportunity to have free and fair trial. And Premier, I think the time has come for us to implement some of the other measures that persons around countries around the world have implemented, like the tracking monitors, the bracelets, and so forth, to give persons an opportunity, while they have some restrictions, not to be remanded at Her Majesty's prison, and it also ease the burden off of the system as well in terms of having persons on remand that should not be at the prison when they don't need to be at the prison. So, Madam Speaker, for me, the main point is for us to really delve into the Section 5 that speaks to what will make up the jury pool. It has been a bane of contention for the legal fraternity for some years. As the member said, it's been in discussion for some 13 years. Yes, it was a subject of the commission inquiry, but I believe this bill was drafted from the Law Review Commission back in 2000, early 2000 or late 2000s, and it's something that we need to move forward. This bill has my support. Madam Speaker, I look forward to a more detailed discussion with the other provisions within the Act. But as I said, the crux of the matter, particularly with this Act, is the issue of the expansion of the pool, and I think it shouldn't be something difficult, that we cannot come to some fair compromise and make sure that, in order to make sure that there's fairness in the process for persons who go before the courts, and that they have the right to a jury of their peers or a cross-section of the community to give them the ability to a fair trial. The point, and there's one other point that the Deputy Speaker raised, and there's a point that I think is an important point, of how do we manage information, the flow of information, particularly with trials, high-profile trials in the territory. And as you know, the BVI is a small society, and social media, our pool of social media connections are very interwoven and intertwined. And we need to find a way to ensure that persons are not prejudiced by the fake news, the fake pages that are created on Facebook that spews misinformation, misleading information, the blogs, as the member mentioned. I know there are restrictions in place currently, particularly with sex crimes, where blogging is restricted for persons who are involved in sex crimes or sex crimes that are before the court. I think we need to look at where enforcement again becomes an issue. We have the Cybercrime Act, which prohibits certain behaviors as relates to online activity, slanderous information, slanderous behavior. We need to ensure that we have the capacity to enforce those elements to sort of protect persons, to ensure that persons have a fair chance to a trial, a fair trial, and to avoid the pollution or the polluting the minds of the jury with fake information or misleading information while a trial is being conducted. There's the discussion of sequestering the jury. I don't know if that's practical in BVI's context. It is something that we could discuss, but we have to look at the practicality of it. But we also have to be mindful of the age that we're living in right now. BVI is no more a newspaper society. Everything is done online, through social media, through the online means, and persons have access to information, whether good or bad, at their fingertips. And those are some of the challenges that we have to grapple with. while we're putting legislation in place to address some of those issues. Madam Speaker, I support the bill, and I look forward to the discussion in the committee stage where we make those very difficult but needed changes and decisions. I thank you.
Thank you, Honorable Member. I now call on the Premier to wrap up.
Thank you, Madam Speaker. Madam Speaker, I would say we've had an interesting debate. Let me reiterate, as my honorable colleague, the Minister of Health, has, that the points raised as it pertains to consultation are extremely important. And I do agree with the territorial at-large member that we have to hold all parties accountable, elected or not, for consulting with the public on the areas under their remit. And it is something that I've been saying from the very beginning, Madam Speaker. Somehow the other persons only started to notice what I'm saying. I've been saying from the very beginning, this has to be a democratic process. Just because we've had a COI doesn't mean that we disregard democracy and consultation. And it's important to say that the COI report said consideration should be given. Consideration should be given. And we have to go through a process. It's also important to note, Madam Speaker, that this is not a new issue. This is an issue that has been ongoing for a number of years. And it's an issue that the legal fraternity has been speaking about and seeking rectification to. Perhaps outside of the legal fraternity, we haven't paid attention as much. But it is the repeal of the Jury Act of 1914 and modernizing it, that predates the COI. And that's been in discussion for quite some time. With your permission, Madam Speaker, I want to read from an article dealing with the matter. And this article, I believe, was from, I think it describes comments from 2019 or 2020. Madam Speaker, with your permission.
Please proceed.
The article said, there is an ongoing travesty of justice in this country, and it is that of the jury system. The Jury Act of 1914 is contrary to the rule of law. It is a violation of the Constitution and all principles of democracy that we still have that Jury Act on our books. I speak for the profession when I make a call for a very urgent rectification of that. Those were the firm words of former Deputy Premier and member of the Inner Bar, Mrs. Dancia Pensala QC, while delivering remarks at the opening of the new law year of the Eastern Caribbean Supreme Court at Sakal Place on Monday, January 13, 2020. Many of the laws on our books need to be revised. The veteran attorney also issued a call to the Virgin Islands legal fraternity to become advocates for social policies and laws. This is a real place with real people, and many of the laws on our books need to be revised. And I know we have a government that is receptive to change, and I think we at the bar can be a great assistance and be stronger advocates for especially social policies and social legislation. According to Pensala, in the same way the legal profession advocates for commercial legislation. She believes it is important that it becomes more involved in advocating for policies and for the enactment of legislation that could help strengthen the social fabric and to promote social justice because it matters, the former legislator added. While Mrs. Pensala did not go into the details of the Jury Act of 1914, which has seen many amendments over the century of its existence, and where it was in violation of the Constitution and a travesty to justice, our newsroom understands there are certain provisions in the law that lawyers have issues with. It was in October 2019 that Justice Anne Marie Smith ordered that the 2019 jury list be squashed and a new list be drafted because she felt there were several defects with its composition, including that there was not enough representation from the sister islands. As a consequence, trials from last October had to be adjourned to January 2020. Justice Smith had said there was no explanation provided to the court that an effort was made to properly remedy the error and deficiencies of the jury list, which were raised in July of 2019, despite the opportunity to do so. Shortly after putting a heavy foot on the issue, which had a major effect on some high-profile cases, Justice Smith was reassigned to Antigua and Barbuda, and his Lordship Justice Trevor Ward, QC, was assigned to the Virgin Islands. The quashing of the jury list and the cancellation of the High Court was described as an unfortunate occurrence by senior resident Judge Vicky Ann Ellis, who stated it's something no court or government wishes to see happen or recall. Ellis, in her address at the January 13, 2020 special sitting, said that the matter brought to the fore a concern that has been growing blatantly for many years in the territory. She noted the problem has been in existence well before the persons who are currently responsible for applying the Virgin Islands Jury Act. Unfortunately, though the experience was, it has been a catalyst for constructive progress. It commenced a policy dialogue which is founded in every dynamic society which is ongoing even here today. It is hoped that we will finally see the reform of the Virgin Islands Jury Act for the benefit of all concerned. Madam Speaker, I just read that to say that there are persons within our society, within our regal fraternity, who have been calling for the reform of this act. And I believe as responsible legislators, we must hear their voice. This is a matter with which I don't have a daily interaction. Certainly, I have to represent the interests of persons who could be on trial and persons who could be jurors. But we also have to listen to the judges. We have to listen to the prosecutors. We have to listen to the defense attorneys. We have to listen and then make responsible judgments. And we cannot look at anything in isolation. We have to look at a total and complete picture. And we really have to do justice to this process that we are going through as legislators. And certainly, it seems very clear to me that the legal fraternity wants to see the Jury Act revised. Remember, 1914 was a very long time ago. And I should put it in context. In 1914, you didn't have anybody voting. Our legislative assembly was suspended in 1901. And we didn't have full universal suffrage until sometime perhaps in the 50s or even beyond that. I have to check the exact time when everyone could vote. And if you notice, Madam Speaker, the requirements in 1914 had to do with persons who could own land and things like that. These were the types of qualifications that were really colonial in their thinking. Because of course we know back in the day who the landowners were during the plantation era. And things have changed considerably since then, and things have changed considerably since 1914. Madam Speaker, I'll also join with the Minister of Health and Social Development and say that we have to be careful how we qualify pairs. We have to be careful how we qualify who is our pair and who is not our pair. For instance, if you have a non-belonger who goes to trial, right? And you have to have a jury of that individual's pairs. Now, who is that? Now, if we're saying whether it belonger or non-belonger, that impacts who is your pair, is that person getting a fair trial then, if it's only quote-unquote belongers on the jury? So I think we have to have an open mind and have a proper discussion. Yes, in most societies you will find that persons who are jurors are on the voters list. The persons who are on voters list in some instances varies. In a place like the United Kingdom, you do not have to be a citizen to be able to be on the voters list. Okay? So, and we have to recognize our unique circumstances as a small territory with a large amount of population who comes from other places. These are the things that we have to consider as responsible legislators. And Madam Speaker, I'm more concerned that we have robust dialogue and conversation about this with the legal fraternity as well as with the public, as the territorial at-large member made a very good point of. We have to have the conversation, and as I said before, Madam Speaker, it's really not about the results you get to. It's really not about the destination you got to, because every society will make different choices for themselves. But did you go through the process? Did you go through the process of discussions? And of course, as has been said before, we've had some difficulties with the process, but we are where we are, and we need to make the best out of the circumstances of where we are, and we need to go ahead, and it's long outdated. 1914 is a long way away. We need to go ahead and have the discussions in committee, make the amendments where they need to be amendments, and live with the results, Madam Speaker. And then if we have to come back again, of course we're trying to get it right on this time, but if we have to come back again, that's the process. That's the process. If it's not working, that's the process. We come back and we amend if necessary. So, Madam Speaker, I certainly present this bill to the House to be able to go to the committee stage and to have some useful deliberations in the committee stage. And I'm grateful, Madam Speaker, for the robust debate and discussion that we've had here today, and I'm looking forward to advancing on this very important bill by the end of today, Madam Speaker. Thank you very much.
Thank you, Premier. It has been moved and seconded that the bill shortly entitled Jury Act 2022 be now read a second time. Those in favor? Those against? The ayes have it. I call upon the clerk to read the bill a second time.
This act may be cited as the Jury Act 2022.
Pursuant to Standing Order 55-1 of the House of Assembly of the Virgin Islands, the bill now stands committed to a committee of the whole House to consider it clause by clause. House is now in committee.